their housing situation, and our team figuring out how we can not only support them in case, but also in making sure that they're stable. We've had a bunch of individuals who, while they've been under supervision, have decided that they're now going to start addressing some of those underlying issues, like going into drug treatment for substance abuse, or finally going and finding a vocational training program that's for free because we've given them that referral. There are so many different types of success stories, and on top of that, being able to then have a case that actually has the most favorable outcome, where they do not now have a criminal charge, is what we've been seeing.
I was just going to add, this is really from my prior experience as a public defender, that the sort of flip side of it is even very, what we would consider relatively short amounts of time in jail can have very debilitating effects. Particularly, I think about young clients I represented, particularly for them, but for pretty much everyone, right? Even after someone stepping in and seeing them 4 or 5 days later, and seeing some of the person across the table from you is markedly different from having had that. It has really quick effects on people. So for individuals who have been able to bypass that, have been able to return home, I mean, it's huge, and I think it's hard to sort of count the benefit of being able to avoid that process altogether.
I think we don't have clients anymore because we don't need to have clients anymore, so that's its own story. When we would pay bail for people who were essentially released on their own recognizance when we paid their bail, because there's like no strings attached, we're not making any requirements of anybody. And I think about people, like you're talking about these short stays, and so I think about people who are living in a shelter. You know, if you don't check into your shelter for 36 or 48 hours, all of your stuff gets thrown out. If you're in a family shelter, your whole family loses their spot in the shelter. We paid bail for people who the next day were starting chemotherapy. If we hadn't paid their bail, they're back on a wait list, which is crazy. And I also think, like Scott was talking about before, there's just countless stories of people who, there's not a story. It's, people who celebrated their birthday with their kid, took their brother to soccer practice, continued, did not lose their job. If you don't call into work for 1, 2, 3 days, you're probably not gonna have it anymore, especially if you're a wage worker. And so, I think about, the hundreds and thousands of people now who have those stories, not because there was some intervention, but because that's now the normal turn of events.
Someone asked, as a public defender, how many times have you represented your client prior to bail reform, informing the individual of the option they have than just bail? For example, Ms. Rodriguez was discussing about having liberty with this new bail reform. However, judges have always had other options than just bail, such as surety bond or partially secured bail bond or unsecured bail, though individuals are unaware and thus face high bail amounts due to the lack of information provided by public defenders. So in reality, how much of an impact does the bail reform have with options that should have already been implemented by judges?
So in terms of the partially secured bonds, fully secured bonds, unsecured bonds, they're essentially additional options that make bail easier to pay for friends and family members of the person who is being held while they figure out how to pay that bail. Those options have been for a very long time. Overwhelmingly, the system, judges and attorneys alike, I think that public defenders also have to take some accountability in this, to be honest, right? Overwhelmingly, insurance company bond and cash were the only 2 options that judges would use. They happen to be the most onerous, the hardest forms of bail to come up with, right? Because if you can't come up with the whole 5,000, 20,000, whatever the amount is set at, then that person stays in. If you don't have something that can cover the collateral that insurance company bondsmen often ask for, then that person stays in. With these other options that have been on the books, They are now, judges, when they can use money bail, for those cases where it's still legal, they can still use money bail. For those cases, what the reform law does is that it requires that judges set bail not in just 2 forms, but it requires that they set bail in 3 forms. And one of the 3 forms has to be a partially secured surety bond. So what does that mean? That means that an upfront payment of up to 10% can be made, and then that secures the person's release. And the person who pays the bail and the person who has been released only has to pay the entire amount if they were to not show up to court after that. So now it's a requirement that where money bail is set, that be an option for payment.
Just to follow up very briefly on that, what that really also looks like and means, I will actually, just taking a step back, one of the hardest parts about being a public defender is dealing with the tension between what you think should be the outcome and what you want to be the outcome for your client and the reality of the person in the robe sitting on the bench, right? And trying to make sure that people have a realistic expectation about what that person will do, but also an understanding that you want the best for them, right? I think it's the thing that, it's the tension that keeps a lot of us up at night as public defenders. But to put a point on what Crystal was talking about, what this, like having a judge required to set partially secured or unsecured bonds means is that when folks are posting bail, they will not have to go to the bail bond company, right, and pay non-refundable fees to a private company, right? So now, if you use a bail bond company, you have to pay them a fee, and even if the person comes back to court the entire time and the bond is lifted, those fees never come back to the family, right? The court, now with a partially secured bond or an unsecured bond, the court, actually just a partially secured bond, the court takes collateral up to 10%. But if the case is resolved and the person comes back to court, all of the money goes back to the family, right? The bail bond company is no longer there. So we are actually, the new law protects people from having to go out and dealing with what are often, bail bond companies, which often folks don't have the best experience with.
If someone has an extensive warrant history, will they be released if arrested?
The question is, if somebody has a warrant history, will they automatically be released? And the answer is, it really depends. So now, if a person is arrested and is coming to court on a non-bail eligible offense, and they continuously miss court and demonstrate to the court that they have no intention on coming to court, then yes, bail can absolutely be set. If a person is charged with a bail eligible offense, then judges are absolutely able to look at that person's history of coming to court in determining whether or not to set bail. In other cases, like low-level misdemeanors and nonviolent felonies, if a person comes to court, then they are required to be released if they are charged with a non-eligible offense in the first instance. But as I sort of explained, that can change if the person demonstrates to the court that they're not going to come back to court.
Thank you. I have to leave, as I mentioned, so Ron, who's my Deputy Public Advocate of Justice and Safety, is going to take over for the time being. So I want to thank this space for allowing me the opportunity to put this on. And again, I'm hoping we can get through. I think what people are really concerned is about being safe, and that's what people's questions are about. Just to remind folks that bail